Welcome viewers to Kanooni CHARCHA. Today I will decodify a judgment of Supreme Court of India having title Madhav Chandra, Pradhan and others versus State of Odisha. This is a Saber petition. This is a Saber special leave petition filed by the petitioner who was facing trial for commission of offences under Indian Penal Code, P OCSO, Prevention of Offences Against Children from Sexual Offences, and the protection of children from sexual offences. There are sections referred, and there is one more act involved, the Prevention of Child Marriage Act. Because in this case, after kidnapping the child, the marriage was solemnized. The age of child is referred as around about 15 years. I will mention the specific date when I will read out the judgment further. He was facing trial. During the trial, the PW1 victim prosecutors was examined in the court. She was cross-examined twice, I think, at length. And after exhausting the cross-examination by the defense counsel, again an adjournment was made from the special judge, who refused. He said, enough is enough. Thereafter, he closed the evidence. Special judge closed the evidence. Against this order of for not granting of the adjourn for again calling the witness to be further cross-examined, an formal application was filed in terms of section 311 of Code of Criminal Procedure. It was rejected by the special judge. Against this rejection order, the petitioner approached the Hon'ble High Court of Odisha by way of filing a petition in terms of section 482 of Code of Criminal Procedure. The Hon'ble High Court dismissed this petition. Thereafter, present SLP was filed by the petitioner before the Hon'ble High Court, the Supreme Court of India, Supreme Court of India, as SLP. Now, the facts of case I have verbally mentioned that it is a case of kidnapping the minor girl, and after that, a child you may refer according to P OCSO, and below 18 years as per the Indian Penal Code, and prohibition of this Child Marriage Act. She is underage. She has not completed the age of 18 years, which is a requirement for solemnization of marriage. Child marriage is prevented as per this act. Now it is required that this while dealing with this special leave petition, Honorable Supreme Court of India, the judges here, the justice, it was two judges bench, namely two bench, Sandashu Dhulia and Asamuddin Amanullah. This judgment is dated 5th of August 2024. The Honorable Supreme Court of India has gone through the order earlier passed by the special judge while rejecting the application filed under section 311 of Code of Criminal Procedure. Thereafter, the order remained upheld, and by an order passed by the Hon'ble High Court of Odisha in a petition filed by the petitioner in terms of section 4 it is. First the Supreme Court of judges here, the date of the minor was date of birth of the child, you may say here, her date of birth was 14th of March 2005, and this kidnapping took place on 30th of August 2020. She was, I have already mentioned, she was having age of this 15 years roundabout. Now, Supreme Court has the prayer made, the case has been, this SLP have been dealt with by taking into consideration the provision under which the earlier the application was filed for recalling the witness for again victim prosecutor for re-examination, you may say, or further cross-examination, you may, anything you may say. But let me read out this section first, 311, what it requires, and then I will read out section 33, subsection 5 of section of this special act, POCSO Act. Now, let me read out for this under which this present application was made before the special judge. Power to summon material witness or examined person present. In those situations, there are two situations. Power to summon material witness are present, that is in the interest of justice. If the Hon'ble Special Judge, Magistrate, whosoever is judicial basis, that it is needed for just decision of the case, it is essential for justice. I will read out now. Power to summon material witness or examined person present, any court may, this is discretion of the particular court, wherever this prayer is made, at any stage of any inquiry. It is not confined to inquiry, trial, or other proceedings. Under this court, summon any person as a witness or examine any person in attendance. If a witness or person, if his evidence is required as a witness, if person is present otherwise in a court, then court can ask him to come in the witness box and record his statement. But now we are concerned with another situation, or examine any person in attendance. This is whosoever is present. It is a person, not a witness. He becomes witness after court thinks it proper that he is required to be examined as a witness. Though not summoned as a witness, this is with regard to person present otherwise not court, or recall and re-examine any person already examined. If somebody as a witness has already been examined, he can be recalled for re-examination. This is a section. And the court shall summon and examine or recall or re-examine. This is three situations. Examine if he is otherwise in attendance and he is being examined first time. This is examination. Recall if he has already been examined and his further examination is required. This situation is another. And re-examine if his other examination is complete. Mean there is a chief examination and afterwards cross-examination of the defects and re-examination. Or this is a re-examination. In this case, I think a request prayer was made because evidence was closed of this witness victim prosecuted by the special judge. Any such person, if his evidence appears to be. Now, question is that by the evidence of this witness is essential. This is also a consideration for exercising discretion by the particular court. Now, section 33. This is 33 of this POCSO Act. Very important. It provides the process how the statement of this child witness is to be recorded, who is a victim of the child particular. Now I will read out section 33 of POCSO. Procedure and powers of the special judge. The trial is this under POCSO is always by special judge as per the statute particular statutory law. A special court may take cognizance of any offence without the accused being committed to it for trial upon receiving a complaint of facts and constitute such offence or upon a police report. Meaning there is no committal proceeding is required. A complaint can be entertained by the special judge or a police report. And this is a para 1 relates to how the proceedings are to be initiated. Next is the special public prosecutor or the case may be the counsel appearing for the accused shall while recording the examination. This is concerned with how the statement. Now, the court should create this friendly, child-friendly atmosphere. He must not be put to any fear. He must be comfortable. She or he, the child here is this is a gender neutral provisions of this POCSO. Communicate this now, but what is a requirement here? How the examination and cross-examination of the accused, this witness, child witness, this victim prosecutor is to be done. It is by framing question. Prosecution, the public prosecutor has to frame the question and give it to the list of the question to the judge. Judge will ask the question. Special judge will put the question to the witness. Not the public prosecutor will direct put these question in chief. Directly to the child. The questions are to be put by the judge, not by the public prosecutor. Who similarly, in cross-examination, defense counsel has to give you may draft of the cross-examination question, and those are to be put by the special magistrate to the child. This is in order to make the child comfortable. There must be, in order to have a fair trial, free and fair trial, transparent trial. He get opportunity, the child get opportunity to divulge the truth whatsoever he is knowing about the occurrence. Communicate the question to be put to the child to the special court, which shall in turn put those questions to the child. This is all with regard to the evidence. The questions are to be put by the judge. There must be this questionnaire and by the PP and as well as by the accused. Special court, next subsection 3. Now I will go directly to this. Let I read out. May it consider necessary permit frequent breaks for the child. In order to keep the child, he may be allowed to have a water. He may be if he wants breaks, the breaks may be given in his examination as a witness. Subsection 4. The special court shall create a child-friendly atmosphere, whatsoever what I have already conveyed, by allowing a family member, a guardian or a friend or a relative, his presence is also good. If she is a mother, brother, anybody who is a guardian, a friend or a relative in whom child has a trust or confidence to be present. But the man, the guardian, should be such a person who upon whom the child is imposed is faith. The section required, particular section which require is to be discussed, required for this case. The special court shall ensure that child is not called repeatedly to testify in the court. What is subsection 5 talks about? That he should not be repeatedly called. In this case, as per the facts of the case, the victim, the child was called twice thrice. And again adjournment sought. And thereafter an application when that adjournment was not granted, or it is on record that she was examined at length, cross-examined at length, repeatedly to testify the court. These things should be avoided. Special court not permit aggressive questions or character assassination of the child, and ensure that dignity of the child is maintained at all the times during the trial. This is special court shall ensure the identity of the child. This is also the child is not disclosed at any time during the course of examination trial. Now, he should not be seen by the accused. But such a situation is to be developed, created, that child may see the accused, but accused should not see this. While I was a special judge, rape cases here, and this when offences, this P OCSO Act, then we used to keep, and under UAPA there is also a protected witness concept. What is needed that I have seen in Delhi courts, the entry of the child witness is separate and accused is separate. There is this you can say a clause, which is tentative clause. Only the witness can see, victim can see the accused, but accused cannot see the child. This is the in order to allow free and this independent examination of the child, or identity of the child should not be disclosed ordinarily. It is also some with when I was judge, I was used to be. Otherwise, law provides that it should be in camera, not in open court. Now, honorable judges, their lordship have discussed and decided that these questions by the prayer earlier disallowed by the special judge and the Hon'ble High Court is to be upheld or set aside. Now, a bare proposal of section 33 subsection 5 of the Act indicates that a duty is cast upon the special court to ensure the child is not repeatedly called to give his or her testimony before the court. He should not be repeatedly called. It is to ensure that child who has suffered a traumatic experience of sexual assault or sexual violence is not called time and again to testify before the same incident. Now, this they have interpreted, they have discussed these two provisions, this 33 subsection 5 of the P OCSO Act and 311 there. Now, they have also taken assistance of another judgment with regard to this section 311 state NCT of Delhi versus Shiv Kumar Jadhav. This is also section referred here. Let us now crux, but is how they have dealt this 311 of the Code of Criminal Procedure, para 6 seems to be relevant. Let us now examine whether the given facts and circumstances plea of the petition for recalling the victim as a witness for re-examination are to have been allowed by the special court. Whether he has rightly refused the prayer of the for recalling of this victim for re-examination. This is the victim here is a girl who at the time of incident was around about, I have already told you about his age, 15 years of age allegedly. It is an admitted fact here that even if your application under section 311 of Code of Criminal was filed by the petitioner, the defense counsel was, this is viewers very important. The defense counsel was given the opportunity to cross-examine the victim twice already. On 22nd of July, this now specific dates are being mentioned. 2023, the examination chief of the victim was conducted, and on the same day, she was cross-examined by the counsel engaged by the petitioner before the special court, means defense counsel. Thereafter, further cross-examination of the victim was deferred to 14th of August 2023 on the request of the counsel engaged by the petitioner. On 14th of August 2023, she was cross-examined at length, and yet again a request for adjournment was made by the counsel engaged by the petitioner, which was then turned down by the special court. Means twice she has been once she appeared, afterwards again she was called, and at length she was cross-examined. Again an adjournment was had without any reason, and after that prayer was refused. After that, present application was filed before the special judge. It was refused. It is then the application under section 311 of Code of Criminals came to be filed by the petition seeking recall of the victim, which was rightly rejected by the order dated 10th of October 2023 by the special. Now, given the finding that it has rightly been rejected, what weighed with the special court while dismissing their application was the fact that after having availed their first opportunity to cross-examination on 22nd of July 2023, the accused sought an adjournment, which was again same is repeated, same dates are repeated in this para. The special court also placed its reliance on section 33(5) of the Act and emphasized that it is mandated to ensure that the child is not repeatedly called to testify. Both the sections, section 311 of Code of Criminal Procedure was also considered, as well as particularly this section was also taken into consideration by refusing the prayer of this section 33 subsection 5 of POCSO, or prayer of this accused to recall the. Now, 9. From the perusal of the record of the case, it is evidently clear that ample opportunities were given to the defense to cross-examine the victim. This is now, hence we find no error or illegality in the impugned order of the Hon'ble High Court or the order dated 10th of October 2023 of the special court. In view of the above, we see no reason to interfere with the impugned order passed by the High Court. This is the what about this judgment I have found by me, and for today. Thank you very much.